pretty much since Caitlin Clark got assaulted in the very first damn game. We done seen countless attacks on Caitlin Clark, and I'm not even finna go through the jacket of playing the videos. We all know what happened at CC. Now, what is crazy about all of this is that the Wall Street Journal, wrote an article earlier this week kind of explaining Caitlin Clark's civil rights being broken. ESPN sports anchor himself, Stephen A. Smith, has spoken about the WNBA should be
The truth that no one else seems to be catching is now as clear as day. While other channels are distracted by baseless rumors about FBI investigations that don't even exist, I've been connecting dots that lead to something far more real, far more dangerous for the WNBA. There's an actual legal roadmap laid out right in front of us, and it starts with Diarra Ham's courtroom victory. This path leads directly to what could become the most significant civil rights case in sports history. I'm Jackson Riley, and welcome back to the channel, where we cut through the noise to follow the digital breadcrumbs to the real story. Today, we're diving deep into the legal precedent that has made Caitlin Clark's situation an absolute nightmare for Commissioner Kathy Engelbert and the WNBA's legal team. If you're new here, make sure to hit that subscribe button, because what we're about to explore is a legal blueprint that other creators have completely ignored. Don't forget to ring that notification bell. What we're about to break down connects pieces that no one else is putting together, and you'll want to be the first to hear it. Here's what we're covering today. First, we're going to look at the Dur-Hami precedent, which proves the WNBA's vulnerability to civil rights lawsuits. Second, we'll break down how Ham's winning legal strategy creates a clear roadmap for Clark's legal team to follow. Third, we'll look at the statistical evidence that makes Clark's case far stronger than Ham's ever was. And finally, we'll address why the WNBA's silence isn't just a PR nightmare anymore. It's a legal ticking time bomb waiting to explode. Let's start with what happened to Diarra Hami, because everything that follows stems directly from her case. In 2023, Hami was traded from the Las Vegas Aces after announcing that she was pregnant. What seemed like a simple roster move, a normal part of any sports season, quickly spiraled into a federal discrimination case that should have sounded alarms for every WNBA front office. But Hami didn't just issue complaints to the media or hope that public sympathy would get her results. No! She took it to the courts and filed a federal lawsuit accusing the Aces of pregnancy discrimination, creating a hostile work environment and retaliating against her. Here's the kicker. She won. In May 2024, Hami reached a monumental settlement with the Las Vegas Aces for a whopping $2.2 million. But the money is just one piece of the puzzle. The real significance of her case lies in what it established legally. This case created what legal experts are now calling a judicial precedent for workplace discrimination claims in women's professional basketball. What's even more terrifying for the WNBA is that the legal framework Hami's team used wasn't complex at all. They simply documented a clear pattern of unfair treatment, hostile workplace conditions, and the WNBA's failure to take action. They proved that the WNBA, as the governing body of the league, failed in its duty to protect its players from discrimination. Does this sound familiar? When you read the legal documents from Hami's case and then look at Caitlin Clark's situation, the parallels are absolutely uncanny. Now, I've been paying attention to the online conversation around Clark, and let me tell you, the temperature around how she's being treated is getting absolutely heated. It's no longer just about basketball disagreements. We're now looking at a much larger issue that could make Ham's case look like a warm-up act. Let me walk you through the legal roadmap, step by step. First, we'll establish a pattern of differential treatment. Ham's legal team successfully documented how she was treated differently from other players in similar situations. But when it comes to Clark, the evidence is far more overwhelming. According to a statistical analysis from the 2024 WNBA season, Caitlin Clark received 17.1% of all flagrant fouls in the league. Despite being just one of hundreds of players, the probability of this happening by chance, according to data analysts, is 0.81%. Let that sink in for a moment. We're not just talking about basketball strategy here. This is clear evidence of something much deeper, something far more troubling. And it gets even worse. The Chicago Sky alone committed 11.8% of all flagrant fouls against Clark specifically. When you can pinpoint a specific team, a group of players, or a series of events where one player is disproportionately targeted with excessive physical contact, you're not just talking about bad officiating or intense play. You're talking about discrimination, plain and simple. This is a kind of evidence that could easily form the basis of a legal case. And if you're not paying attention to this, you're missing a crucial part of the story.
Talk about Caitlin Clark and the idea of a government probe or an investigation in a hostile work environments being conducted by the government because of the actions that the league itself and some of the players have had.
The second major element from Ham's successful legal strategy is documenting a hostile work environment. This is where Sophie Cunningham's revelations become absolutely critical. Cunningham, who is now a teammate of Caitlin Clark's with the Indiana Fever, shared some key insights into locker room discussions that she had during her time with the Phoenix Mercury. She admitted that the conversation among teammates often centered on how aggressively they should play against Clark. In particular, the talk was about making Clark earn every inch of space on the floor. Now, let me tell you, these were not casual game planning discussions. Cunningham, in her own words, revealed that these were strategic talks about setting a physical tone early in the game, about sending a message to Clark. This is where it gets legally significant. In employment law, when you can prove that coordinated hostility is taking place in a workplace, you're halfway to building a solid hostile work environment claim. This is huge for Clark's case. What's even more striking is the shift in mainstream media. Initially, ESPN analyst and former WNBA star Rebecca Lobo dismissed the idea of targeting Clark. But now, she's come around and acknowledged that the officiating patterns have been problematic. This shift in perspective by respected figures is what legal experts call expert witness development, and it gives even more weight to the claims being made against the WNBA. The next critical aspect we need to look at is league inaction and the failure of duty of care. This is where Commissioner Kathy Engelbert's silence is becoming legally dangerous for the WNBA. In Hami's case, the legal team established that the WNBA has a legal obligation, a duty, to protect its players from discriminatory treatment. When the league fails to address or even acknowledge documented patterns of harassment or unfair treatment, they open themselves up to legal liability. When you look at Clark's case, the evidence of the league's inaction is absolutely glaring. Take, for instance, Kennedy Carter's blindside hit on Clark. No ejection. Diamond Deals' linebacker-style tackle. No suspension. Marina MRE's deliberate shove. No fine. Tina Charles's back contact incident. Not even acknowledged. Each time the league fails to take action or discipline players for these flagrant fouls, it builds another piece of evidence in favor of Clark's case. The Wall Street Journal's Sean Land, a former White House staffer, even published a piece suggesting that Clark's treatment might warrant a federal investigation into civil rights violations. When former federal officials start using that kind of language, it signals that the case has reached a level where federal scrutiny is imminent. So, here's the bottom line. What do we know for sure? We know that Hami successfully sued the WNBA for $2.2 million using workplace discrimination laws. We know that Clark's statistical targeting rate is documented and statistically impossible to be random. We know that player testimony has confirmed coordinated targeting. And we know that the WNBA has consistently failed to discipline players for flagrant contact against Clark. Now, let's talk about what's still speculation. Nothing's confirmed yet, but the chatter online is too loud to ignore. Indiana Representative Jim Banks has sent a formal letter to Commissioner Engelbert demanding answers about Clark's treatment and the league's protection measures for her. That's a legitimate sign of federal interest in the case, not a criminal investigation, but it's enough to get attention. And on top of that, Stephen A. Smith made a suggestion on ESPN that the situation could become a political issue for the Trump administration to leverage, comparing it to Columbia University's massive $221 million civil rights settlement. This prediction suggests that the political weaponization of Clark's case could turn this entire situation into a constitutional rights battle, not just a sports issue.
to grow legs, because a lot of people is going to speak out about this. And I'm telling y'all right now, people from behind the scenes sources have told me as a recent, now I wasn't going to say nothing, that Caitlin Clark agent could possibly allegedly be behind.
Now, let's talk about the explosive speculation surrounding Clark's agent potentially orchestrating federal attention. It may sound shocking, but honestly, it could be brilliant legal strategy. If Clark's legal team is building a case based on the legal precedent set by Hami's case, they would want maximum documentation of the WNBA's failure to protect her. Every uncalled foul, every ignored incident, and every moment of silence from the league becomes a piece of evidence for their case. This would explain why Caitlin Clark herself has remained relatively quiet about the targeting she's facing, while her teammates, analysts, and even political figures are becoming increasingly vocal. In discrimination law, it's critical not to give the appearance that you're seeking special treatment. At the same time, you need to build a solid case, showing that you're being treated unfairly. The economic pressure on the WNBA is already through the roof. Clark's presence alone has led to a staggering 380% increase in WNBA TikTok engagement, a 600% surge in merchandise sales, and television ratings that dwarf games without her participation. The league is essentially gambling with its most valuable economic asset, all while creating potential legal liability for themselves. If Clark's team follows Ham's legal blueprint and wins a discrimination case, the financial fallout for the WNBA could be catastrophic. This goes way beyond just paying out settlement money. Civil rights violations could trigger federal oversight, the loss of broadcast privileges, and sponsor withdrawals, all of which would threaten the entire future of the league. This is the point that other channels have completely missed. While everyone else is chasing unverified FBI investigation rumors, the real danger to the WNBA comes from established legal precedent and hard evidence. Hami proved that WNBA discrimination cases can succeed in federal court, and now Clark's situation provides even stronger statistical evidence and a broader pattern of discrimination. The WNBA has built its brand as a league of empowerment and social progress. But if they're faced with a successful civil rights lawsuit from their most visible player, it could destroy their entire brand identity. As Stephen A. Smith predicted, the political weaponization angle is already starting to take shape. Federal figures are starting to ask questions, and media coverage is shifting to frame this as a constitutional issue rather than just a sports officiating dispute. The longer the WNBA waits to address Clark's treatment and protection, the more ammunition they give to the discrimination claims. But here's where it gets really interesting. The Department of Justice doesn't even need to launch a formal investigation for a civil rights case to proceed. Private lawsuits, using the legal framework established by Ham, can move forward independently of federal agency involvement. If Clark's legal team files a discrimination lawsuit based on Ham's precedent, the WNBA will face a discovery process that could expose internal communications about Clark's treatment, targeting strategies, and officiating decisions. Imagine a deposition where WNBA executives are forced to testify under oath about why Clark is receiving disproportionate targeting without any disciplinary action. Picture team officials having to explain locker room discussions about coordinated physicality. Think about referees being questioned about inconsistent officiating standards for different players. The discovery process alone could be absolutely devastating for the WNBA's reputation and its competitive position in the sports world. The corporate sponsors, which have been so critical to the WNBA's financial success, are not going to want to associate themselves with an organization facing civil rights lawsuits. Even if the lawsuit is eventually settled or dismissed, the damage to the WNBA's brand and marketability could be catastrophic. That brings us to the economic angle of this legal fight. Caitlin Clark has proven that one player can dramatically change the financial landscape of an entire league. Fever games are now requiring larger venues to meet ticket demand. WNBA League Pass subscriptions are at record levels, and merchandise sales featuring Clark's name and number have skyrocketed by more than 600%. She is the most valuable asset the league has, and yet the WNBA has failed to protect her from the very real risks of injury and legal liability. Clark's legal team will want to document every moment of targeting and league inaction before filing any claims. Every game that passes without the WNBA taking action to protect her strengthens the case for discrimination. The longer the league waits, the harder it will be to defend themselves legally. As the federal interest in this case grows, and as the media continues to cover it, the pressure on the WNBA is only going to increase. The legal precedent is already in place, and the economic stakes are higher than ever. The competitive landscape for WNBA content creation is about to change dramatically. This story has evolved beyond a simple sports controversy. It's now a constitutional rights issue, and the legal roadmap from Ham's precedent to Clark's case is about to set the stage for the next major legal battle in sports history. So, I have a question for all you narrative analysts out there. Do you think Clark's legal team is already building a discrimination case using Ham's legal framework? Are we watching strategic legal preparation disguised as sports controversy? Drop your thoughts in the comments below, because this is a meta-narrative that's still developing. If this breakdown helped you understand the legal roadmap that other channels are missing, make sure you subscribe for more competitive intelligence analysis. Hit that notification bell because this story is evolving fast, and you won't want to miss what happens next. Share this video with anyone who needs to understand the legal precedent behind Clark's situation, because the discrimination angle is about to change everything about how this story develops.